Good afternoon, viewers at home. You're welcome today to another episode of Insights from Eximators Legal. My name is Esther, your host. Today, we shall be enlightening one another on a crucial aspect of financing of international trade, which is one of the key arms of international commercial law, relating more to banking law. This is a very interesting concept in international finance, and it's something that is very practical for businessmen that deal with global trade. Our topic for today is letters of credit and the doctrine of strict compliance in international trade. The letters of credit is also known as documentary credit or bankers' commercial credit. It's a very important tool in the finance of international trade. So parties involved in international trade from different countries, they arrange payments to one another through letters of credit most of the time. And it actually gives room for ease of payment. So a businessman in Japan can ship goods down to another businessman in Nigeria without having any problem about whether the payment for the goods is going to be certain. Because via a letter of credit, this provides an assurance to the seller overseas. There are various applicable rules to the letters of credit. We're going to be discussing some of them. Majorly, we have the Uniform Customs and Practice for Documentary Credits, which we call the UCP. The recent one now being used is the UCP 600. So the law and practice of letters of credit transactions internationally is actually standardized by the Uniform Customs and Practice for Documentary Credits. So it aims at harmonizing worldwide trade practices and safeguards the interests of international trade and the banking community. So the UCP has, if we must understand that this rule is a self-regulatory regime in that it's not a legal regime that automatically applies to all letters of credit, but it applies if parties incorporate the terms into their own letters of credit and says that UCP will guide their letter of credit transaction. Definitely, the UCP 600 will apply. So when the text of the credit expressly indicates that it is subject to the UCP rules, then the articles of the Uniform Customs and Practices for Documentary Credits will apply in governing the letters of credit regarding the relative transaction. So what is letters of credit? So the concept of letters of credit is used majorly, like we have mentioned earlier, in financing international trade. So in delivery for provision of goods, services, you use letters of credit to make payments, to assure payments to the seller or the exporter, as the case may be. So the letters of credit are actually undertakings to honor documents representing the delivery of goods and services. So the way it works in practice is it's a term used on the basis of the fact that uncertain documents have been presented by the seller. Then the bank, in whose custody the letter of credit has been issued, will make payments to the seller upon receipt of certain documents have been specified for the transactions. So majorly the way it works is, once the seller shows definitely that yes, all the documents are okay, It enables him to know in advance that the criteria against which the banks will examine the shipping documents in deciding whether or not to make payments to him. So for the buyer, incorporation of the UCP rules will make them know in advance the criteria against which the price for the goods will be paid against tender of documents. So the letter of credit, as we have mentioned, is a lifeblood of international commerce, as most courts, based on certain decisions, have referred to it. So it's defined as a promise by a bank of immediate or future payments to the seller against specified documents on terms that the bank will be reimbursed by the buyer. So majorly, what this means is the moment a buyer or an importer goes to the bank and issues a letter of credit in favor of the exporter of the seller, what it's definitely saying is, once you get these certain documents from the seller, then you can make payments to the seller for the goods. So the letter of credit don't actually deal with the sales transaction between the parties. The major thing is, have the documents that the seller is supposed to present, has it complied with what parties have agreed? In Nigeria, like we have the UCP rules that governs the worldwide international transactions for documentary credits. The External Trade Letters of Credit Control Act is the national legislation that regulates letters of credit in Nigeria. And it defines the letter of credit as any undertaking or authority in writing, whether or not against production of any document or documents given to finance payment in respect of overseas goods or services on account of any person resident in Nigeria. So the way letters of credit are used, they're majorly used to finance transactions from overseas between the importer and the exporter. So we're going to move forward now to really explain what LCs, letters of credit, are in practice. In a developing country like Nigeria, you cannot overemphasize the significance of the letters of credit in international trade arrangements, because it gives a comfort to a certain extent to the seller abroad to know that upon shipping of the goods and presentation of certain documents to the bank, he or she is assured of payment. So the letter of credit is basically separate from the sales contract between the parties. We need to know that. So banks are not concerned with the underlying contracts between the parties, whether parties have fulfilled the terms of the contract. What the bank is majorly concerned with is, are the documents that the buyer have informed them that, okay, once you see these certain documents, once these documents are complied with, all these documents are submitted by the seller, then you can go ahead and pay. What are the advantages of the letters of credit? The letters of credit transaction poses two main advantages as a means of finance in international trade. First, it enables the seller, as an exporter, to obtain payment immediately for the price of the goods upon shipment. So the moment the goods are shipped, once the seller is able to produce the requisite documents as agreed to the bank, then based on the LCE issued, the letters of credit that has been made in favor of the seller, then the bank can go ahead and pay. So for as long as the bank is a going concern, as long as the bank is solvent, the seller is assured of payment, provided he's able to meet all the terms of the credits, which is majorly complying with the documentary evidence that's supposed to be submitted. Second advantage really to the buyer is it enables the buyer as the importer to get credit upon security of title documents with the bank. So the importer, the buyer in this case, in another country, issuing a letter of credit in favor of the seller in another country, as long as he has a letter of credit issued with the bank, he knows that the company he is buying from, or the individual is buying from, is going to be paid. So it gives the importer or the buyer, in this case, the opportunity to get credit upon security of title documents with the bank. So we could say more or less that the letters of credit relies on the creditworthiness of the buyer's bank. So we want to discuss certain terminologies regarding the parties to the letters of credit transaction. So we mentioned the UCP 600, which is the Uniform Customs and Practice for Documentary Credits. And Article 2 of that UCP 600 actually outlines some parties that are involved in a letter of credit transactions. So who is the applicant in the letter of credit? Excuse me. The applicant is the party on whose request the credit is issued. In this case, is the buyer or the importer. So somebody importing goods into a country goes to his or her bank to apply for a letter of credit in favor of the seller of the exporter in another country. So the applicant is the party on whose request the credit is issued. The beneficiary is the party in whose favor a credit is issued. So the beneficiary in most of the cases is the exporter or the seller. Then we have the issuing bank as another party to the letter of credit transaction. The issuing bank is the bank that issues a credit at the request of an applicant or on its own behalf. So the issuing bank in most cases is the bank of the buyer or the bank of the importer. So that's the issuing bank that issues the letter of credit in favor of the seller or the exporter. Then we also have the advising bank. This is the bank that advises the credit at the request of the issuing bank. So in this case, the issuing bank issues the credit at the request of the applicant. The advising bank advises the credit at the request of the issuing bank. Then we have the confirming bank. The bank that adds its confirmation to a credit upon the issuing bank's authorization or request. So the confirming bank could be a bank in the exporter's country, not necessarily in the importer's country. So we have the confirming bank that adds its own confirmation that, yes, I guarantee that this bank has issued this credit in favor of the beneficiary. And they are still putting their own confirmation to give an extra mile of assurance to the seller that, yes, definitely, once certain document has been produced, the money for the goods or the services will be paid. And we also have the nominated bank. The nominated bank is the bank with which the credit is available, or any bank in the case of a credit available with any bank. So there could be a nominated bank, in which case they nominate the bank that, okay, yes, this money is available with this bank. So the issued bank could nominate another bank as in the nominated bank. So at times there are some technicalities involved in this. In certain letters of credit transaction, you could only have 4 parties, not all the parties, as we have listed. So in some letters of credit transaction, we could only have the applicant, the beneficiary, the issuing bank, and the confirming bank, and the seller will be paid. But in certain instances, maybe because of the complexities of the countries involved, where the businessmen are residents, or where the businesses are residents, there could be need for the advising bank. There could be need for the nominated bank. There are other applicable terms defined in letters of credit, such as presentation. So presentation means the delivery of documents under a credit to the issuing bank or nominated bank. So presentation is done in practice by the seller and it's in relation to the documents that are supposed to be presented. We're going to go into that as we move forward. Then the presenter is the beneficiary or the bank of the beneficiary that will present the documents to be able to get payment from the issuing bank or the nominated bank. So letters of credit could operate in 4 stages. We're just going to go through that to have a proper understanding of how it works in practice. So the seller or the exporter and the overseas buyer. I've worked in the manufacturing. I have an idea of how this works in relations to bank. The industry in Nigeria will go to their bank and get LCs, letters of credit, issued in favor of their counterpart raw material supplier abroad. So the seller and the exporter, the seller and who is the exporter, and the overseas buyer, who is the importer, they both agree in the contract of sale that the payment will be made under a letter of credit. So there's an initial agreement between both parties to the transaction. That's the seller and the buyer in different countries that, okay, I'm going to finance the payment for these goods, for these raw materials, or for these services by the letter of credit. So the overseas buyer, who is the applicant, approaches the bank in its own jurisdiction and instructs the bank, who is the issuing bank, as we have explained earlier, at its place of business or country, to open a letter of credit in favor of the seller, who is the exporter, outside the country. And the exporter or seller, as we have said, is the beneficiary. However, the buyer, or the importer in this case, will specify certain instruction to its bank, the issuing bank, for opening of the credit. So the moment the buyer approaches the bank, he tells the bank, on this so terms, open the credit to this seller abroad. So the issuing bank will in turn make arrangements with a bank in the seller's place of business or country. That is the advising bank. So let's say, for instance, I'm using a bank in Nigeria, and I'll use another bank in the UK for us to understand. So, for instance, a businessman in Nigeria wants to get supply from a businessman in the UK. They've been transacting business. It's going to be financed by a letter of credit. The businessman bank in Nigeria approaches his bank in Nigeria, let's say First Bank, for instance, of Nigeria. First Bank issues the letter of credit in favor of businessman B in the UK. First Bank in Nigeria makes another arrangement with a bank in the UK, let's say, for instance, Lloyds TSB in the UK. So Lloyds TSB in this case is the advising bank. First Bank of Nigeria in this case, in our example, will be the issuing bank. So the advising bank, also known in certain parlance as the correspondent bank, will negotiate, accept, or pay the seller's draft upon the sellers presenting the specified documents in accordance with the terms of the credit. We should not forget that we mentioned earlier that the buyer would tell the issuing bank, upon certain specified documents presented, payments should be made to the seller. Now the issuing bank gives another bank authority in the seller's place of business outside his own jurisdiction to pay upon receiving those documents. So the advising bank will inform the seller, or the exporter in this case, that yes, is going to negotiate, accept or pay the draft upon delivery of the specified documents. So the advising bank in addition also gives notification of the credit to undertake to confirm the credit. So the advising bank in this case could also act as the confirming bank to say that giving a level of assurance and guarantee to the seller that payment will be made. Main thing is just supply all the necessary documents. It could be, there are different documents that needs to be supplied based on terms between the buyer and the seller. So some of them, the shipping documents, could be the bill of lading, the invoices, things that relate to the packing of the goods, depending on if it's raw materials or services, things like that. So each transaction have their own specified documents based on the parties' agreements between them. So when the advising bank or the correspondent bank adds its own confirmation, then it could pay the seller in its own country once the terms of the credit has been complied with. So, what we're invariably saying here is that the buyer's liability to the seller is a primary liability, as a letter of credit is not really absolute payment as it is until the terms of the credit are strictly complied with. So if maybe one of the documents that is supposed to be submitted is missing, the seller do not get to be paid. Those are part of the downside of the letters of credit, and we'll see that as we move on. So letters of credit could be arranged easily for a one-time transaction between the exporter and the importer. Or it could be a revolving, ongoing payment terms for a series of transactions, depending on the agreements between the parties. And unless the conditions of the letter of credit state otherwise, ideally, every letter of credit cannot be revoked. It should be irrevocable. So which means the documents that are supposed to be presented by the seller cannot be changed. The letter of credit cannot be cancelled unless the importer, the bank, and the exporter all agree. There are different forms of letters of credit. There are some special forms of letter of credit, and we're going to touch on that briefly. When a letter of credit is made transferable, the payment obligation under the original letter of credit can be transferred to one or more beneficiaries. So, if the letter of credit that is issued is one that is transferable, so a beneficiary A can transfer that letter of credit to another beneficiary, meaning that instead of paying the original beneficiary that money, he could nominate somebody else to be paid because that letter of credit is a transferable one. We have revolving letters of credit, so which implies that the issuing bank restores the credit to its original amount each time it's drawn down. So a revolving letter of credit means that the buyer has an arrangement with its bank, which is the issuing bank, to say, yes, let's say like, okay, $10,000 letter of credit is issued in favor of the exporter. The moment that money is paid off, another $10,000 is put there, again, as a letter of credit that the buyer, or the importer in this case, can draw upon. So the letter of credit is revolving based on the arrangement between the buyer or the importer and its bank. We have what we call standby letter of credit, because this happens in certain jurisdictions that though not intended to serve as a means of payment for goods, but the standby letter of credit can be drawn in the event of a contractual default, including the failure of an importer to pay invoices when due. So if the seller has a standby letter of credit with it or a bank, that means in case of any default, at least the importer or the buyer can have recourse to that letter of credit that is standby, as the name implies. in case of a default. Similarly, for standby letters of credit, they are often posted by exporters in favor of an importer because they can serve as a bid, bonds, performance bonds, advance payment guarantees. So things like standby letter of credit, it's not always like the normal kind of letter of credit. They are just there in case as a standby. So we want to go into the fundamental principles of the letters of credit. So the law relating to the letters of credit worldwide, as at today, is founded on two major principles. And these two principles, they are very crucial and they determine a lot in letters of credit transaction. The first one is the principle of independence of the credit, while the second one is the doctrine of strict compliance. We're going to explain the principle of independence of the credit. This is a principle that implies that the credit is autonomous. In this context, the letter of credit is supposed to be treated as an independent and separate transaction from the underlying contract between the buyer and the seller. So that's the principle of independence. So it has nothing to do with whether, the goods were supplied, the goods were defective. No. It majorly deals with payment for the goods upon presentation of the documents. We're going to just read something about this, that the article in the UCP states. Article 4A of the UCP 600. I'm going to quote. It talks about the principle of the autonomy of the credit. And it says a credit is, by its nature, is a separate transaction from the sale or other contract on which it may be based. Banks are in no way concerned with or bound by such contracts, even if any reference whatsoever to it is included in the credit. So what it means is a bank is not concerned with the sales transaction between the parties. All the bank is concerned with is whether the documents the seller tenders correspond to those specified in the credit instruction. That's simple. That is what the bank is concerned with. So the only instance under which an issuing bank or an advising bank that's supposed to make payment to the seller would not pay is if it is proved to the satisfaction of the bank that the documents, even though they conform on their face with the terms of the instruction, are forged, and that the beneficiary has knowledge of the fraud, then the bank will not pay. Apart from that, once documents comply with the specified terms of the credit, then banks are ideally obliged to pay. The second principle, which is really the main principle that governs the letters of credit, is what we call the doctrine of strict compliance. Letters of credit transactions, being documentary in nature, are judged by the principle of strict compliance. And the first rule of this doctrine is that all the specified documents need to be tendered. Nothing must be missing. So if the buyer that approaches his or a bank, the issuing bank, and says, this document A, B, C, D, once the seller tenders it, then payments can be made. The banks have to strictly adhere to that. So this principle of strict compliance, it actually presents that the documents tendered by the beneficiary to the bank shall strictly conform on their face with the documents specified under the terms. So once it can be established, yes, this is the bill of lading, this. they can see that, yes, they conform to the terms stipulated under the credit, then the banks can go ahead and pay. Article 5 of the UCP 600 explains and establishes this doctrine in the sense that banks deal with documents and not with goods, services, or performance to which the documents may relate. The bank could only reject documents when they know it's fraudulently made and it can be established that, yes, the beneficiary knows about the fraud, or at the smallest discrepancy in the documents, the banks would not make payments. So the rationale behind this doctrine of strict compliance is that the banks act as agents of the buyer. And in the law of agency, you have to comply with what your principal tells you to do. So the issuing bank, in this case, is an agent of the buyer. The buyer is the applicant for the credit. So if the agent of the buyer, which is the issuing bank in this case, exceeds its authority given in the credit instruction by going ahead to pay when the documents do not conform, then the buyer is not bound to ratify the act of the bank in that case, and it will not be liable to reimburse the bank for any payments made on non-conforming documents, regardless of whether or not the goods have been shipped to the buyer. So, what we're invariably saying in this case is, even though the seller tenders documents that look similar, it is still not acceptable under the doctrine of strict compliance. What are the effects of this doctrine of strict compliance on the finance of international trade? It is very significant to the buyer. It's a key principle to the buyer, to the seller, as well as to the bank in financing international trade. To the seller, since letters of credit are transactions in documents, if the document conforms to the terms of the credit, the bank must honor its payment obligation under the credit. This gives the seller certainty of payment, and this gives letters of credit transaction its own uniqueness. On the other hand, it ensures that the seller produces the required documents, which also assures the buyer, as the applicant for the credit, that the stipulated documents will be made available to him by the bank. With respect to the bank, the doctrine spares the bank from value judgments about discrepancies in tender documents, meaning that it prevents the bank from scrutinizing the sale transaction between the parties because it's not within its scope of normal business. His own is to look at documents. Once the documents conform, fine, the bank can go ahead and pay. So exporters, that's the sellers abroad, overseas, should consider getting confirmed letters of credit if they are concerned about their credit standing of any issuing bank. So because of the volatility of the economies around the world, it's always advisable that the issuing bank gets an advising bank to confirm in the seller's jurisdiction the payment. So when they're operating, especially in a high-risk market where there's a lot of political upheaval, economic lapses, devaluation, exchange control issues, it could put payment at risk. But once confirmed LCs are issued, confirmed letters of credit, there's a corresponding bank in the seller's jurisdiction that will confirm that yes, payment will be made once documents are submitted. It gives the seller a level of comfort. And also, the exporters should also consider getting confirmation of their letters of credit when the importers, the sellers in this case, are asking for extended payment terms. Because with trade, amongst businessmen, among companies in different jurisdictions, buyers could request for extended payment terms. But once the letter of credit issued can be confirmed by a correspondent bank, like we said earlier, it will definitely give the seller on the other side the opportunity to be assured that regardless, once documents are okay, payments will be made. So today, we've been able to basically summarize the concept of the letters of credit as well as the principle behind it when it comes to the doctrine of strict compliance. So to recap, we have defined letters of credit as documentary credits or bankers' commercial credits, and that they are undertakings to honor documents representing the current delivery of goods or services. We have defined it as a promise by a bank of immediate or future payment to the seller against specified documents on terms that the bank will be reimbursed by the buyer. So I believe today we've been able to see different advantages of the use of letters of credit in international trade, the parties to the letters of credit transaction, and why it's important to have a confirmed letters of credit issued in favor of the seller or the exporter, as the case may be. So thank you very much for joining us this week. There is always more to learn when we are open to. Have a blessed weekend.